When a debt buyer can't prove their case, what is one powerful legal tactic that you can use to get your case dismissed? That's the topic of this video. Hello again, everyone. I'm attorney Robert Flessas. There's a powerful legal tool that's available to you that you can argue to a judge. And if it's successful, your case is dismissed. That means you won. It's called summary judgment. I'm going to explain how it works and where it fits into your case. But first, if you find my videos useful, please consider subscribing to my channel and share my videos with others in your same predicament. Okay, let's get into this. A summary judgment is where a judge rules on a lawsuit without requiring the case to go to trial. When a judge makes a ruling that the debt buyer hasn't proved their case, the judge is saying that the case is obviously in favor of you. You don't need to go any further on the case. Here's an example of how you use this powerful tool against the debt buyer. The debt buyer files a complaint and alleges that you owe them money because they purchased the debt from the original creditor. As we all know from my other debt buyer videos, the debt buyer is telling the court the following: that you had a contract with a previous creditor. You used a credit card. You didn't pay the creditor back. Eventually, the creditor sold the debt to the debt buyer. The debt buyer, as the new owner of the debt, alleges that they contacted you by letter stating that you now owe them for the debt. You didn't respond to their letter or phone calls. The debt buyer then files a collection lawsuit against you to collect the money, and you respond with your written answer. Now the case begins. The next step in the case is the discovery process, where the parties share evidence. You give the debt buyer's attorney a document called a request for production of documents. Now, you can download that document in the comments below for a small fee if you want to use it for discovery. You don't have to. In the request, you're asking for very specific documents from the debt buyer. You want, for example, a copy of the original contract, proof that they purchased the debt, and if the debt has been validated, among other documents. After discovery, you know that the debt buyer can't prove that they own the debt. They can't even produce the original signed contract between you and the original creditor. Well, the next step in this case would be a trial. But do you and the debt buyer really need a trial? All of the evidence in the discovery portion of the case shows that the debt buyer can't prove their case. If there was a trial, the judge would have to rule in your favor based upon the evidence. Here's how the legal tool fits in. You move the court for summary judgment because all of the relevant evidence has been disclosed and the debt buyer can't provide it to you. If the judge agrees with your contention, then the judge considers your statement. There's no relevant evidence that the debt buyer can provide to prove their case. The judge then states that there's no need for a trial. It would be a waste of the court's time. If the judge finds that there is no need for a trial, then the judge grants your motion for summary judgment and you win. The judge orders the case to be dismissed and the case is now over. The debt buyer loses. That's how simple it is, and that's why you need to request documents from the debt buyer during the discovery stage of the case. Well, I hope this was useful to you. Remember to subscribe, like, and share. I'm attorney Robert Flessas. Thanks for watching, and I'll see you in the next video.